Hello friends, today we are going to understand the topic Intellectual Property Appellate Board. First, we have to understand what is Intellectual Property Appellate Board. Section 83 of the Trademark Act 1999 required the central government to establish an appellate board to be known as the Intellectual Property Appellate Board to exercise the jurisdiction, power and authority conferred on it upon the Act. The composition of the Appellate Board. The Appellate Board consists of a chairman, a vice chairman, number of the other members as the central government, and the qualification of the chairperson that is or has been a judge of a high court or has held the office of a vice chairman for at least 2 years. The qualification of vice chairperson as he has held the office of a judicial member or a technical member for at least 2 years or has acted as a member of the Indian Legal Services and also has held a post in grade 1 of the service or any higher post for the least 5 years. The jurisdiction, power and authority of the appellate board may be exercised by benches. A bench consists of a judicial member or a technical member shall sit at such place as the central government may specify. Chairperson may, in addition to discharging the function of the judicial member, technical member, transfer a member from one bench to another bench, authorize the vice chairperson, the judicial member or the technical member appointed to one bench to discharge only the functions of the judicial member or technical member of another bench. The central government may make provision as to the distribution of the business of the appellate board and specify the matter which may be dealt with each bench. Section 84 of the Trademark Act 1999 says that where any question arises as to whether any matter including an appeal under Section 91 falls within the purview of the business allotted to the bench, the decision of the chairperson shall be final. Section 84, Subsection 6 deals with the difference of opinion. Where the members of the bench differ in opinion on any point, they shall state the points on which they differ and make a reference to the chairperson. The chairperson shall either hear the points himself or refer the case for hearing on such points by one or more of the other members, and such points shall be decided accordingly. The opinion of the majority of the member. Now, we are going to deal with the appeals to appellate board. Section 91 of the Trademark Act makes provisions for appeal to the appellate board from the decision of the registrar. It provides that any person aggrieved by an order or decision of the registrar may prefer an appeal to the appellate board within 3 months from the date on which the decision sought to be appealed against is communicated to such person preferring the appeal. An appeal may be admitted after the expiry of the period if the appellant satisfies the appellate board that he had sufficient cause for not preferring the appeal within the specified period. Section 93 deals with that no court or other authority shall be entitled to exercise any jurisdiction, power or authority in relation to the aforesaid matter. The powers of the appellate boards are: Section 92 deals with the power. Make it clear that the appellate board is not to be bound by the procedure laid down in the CPC 1908. The board is to be guided by the principle of natural justice. The board has the power to regulate its own procedures, including the fixing of places and times of its hearing. The board has the same power as are vested in the civil court under the CPC. The first one, receiving evidence, issuing commission for examination of witnesses, requesting any public order, any other prescribed matter. Any proceeding before the appellate board is to be deemed to be a judicial proceeding for the purpose of difference provision of IPC. Now, we have to understand what are interim orders. No interim order, whether by way of injunction or stay or in any other manner, is to be made on an appeal unless copies of such appeal and all documents in support of the plea for such interim orders are furnished to the party against whom such appeal is made or proposed to made. Section 95 says that opportunity is given to such party to be heard in the matter. Section 96 deals with the transfer of cases from one bench to another. Empowers the chairman to transfer any case pending before one bench from disposal to any other bench, either on the application made by an of the parties after hearing them or on his own motion. 97 section deals with the rectification of register, deals with the procedure for application for rectification made to the appellate board, and application for rectification of the register under Section 57 may be made to the appellate board in the prescribed form. A certified copy of every order or judgment of appellate board regarding to the registrar trademark is to be communicated to the registrar by the board. The registrar is to give effect to the order of the board and shall amend the entries or rectify the register in accordance with such order. Section 98 deals with the appearance of registrar in legal proceeding, that empowers the registrar to appear before the appellate board. The registrar has a right to appear and to be heard. The first one, legal proceeding before the appellate board, includes alteration or rectification, appeal to the board from an order to the registrar on an application for registration of a trademark, which is not opposed and the application is either refused by the registrar or accepted by him, subject to any amendments, modification, condition or limitation, which has been opposed and the registrar considered that his appearance is necessary in the public interest. The registrar shall also appear in any case if so directed by the board. The registrar may appearing submit a statement in writing signed by him. The purpose of the registrar being required to appear before the Intellectual Property Appellate Board is to assist the pending proceeding before it is on legal issue. Relevant to the issues and within the knowledge as registrar, such statement can be used as an evidence, as in the case Mount Everest Mineral Water Limited versus Bisleri International. In the section cost of registrar in proceeding, it also proceeding before the appellate board, the cost of the registrar shall be in the discretion of the board. However, the registrar shall not be ordered to pay the cost of any of the parties. Section 100 deals with the transfer of pending proceeding to appellate board, provides for the transfer of all cases of appeal and rectification proceeding pending before any High Court to appellate board from the date of notification to the official gazette. The appellate board may proceed with the matter either de novo or from the stage it was so transferred. In the case Naresh Kumar Jain versus Union of India in the year 2009, the appellate board has liberty and discretion to try and decide whether de novo proceeding from the matter was transferred should be held. In the case Shiva Tobacco Company versus Rakesh Kumar Jain in the year 2004, when a legislative enactment inclusive jurisdiction is given to a particular authority, the jurisdiction of the other court to entertain the same. In the certificate of validity in any legal proceeding for rectification of the register before the appellate board, if a decision is given in favor of the registered proprietor of the trademark regarding validity of the registration of trademark, the appellate board may grant a certificate to that effect. In the section 141, where a certificate is granted, the legal proceeding relating to the validity and the proprietor obtaining a final order or judgment in its favor, affirming validity of the registration of trademark and expenses as between legal practitioner and client. Thank you.